Let me get my screen up and get this ready to share. Okay.
All right, you're good to go.
All right.
So, Erika, do you want to start?
Oh, sure. We live.
Yeah, we are.
All right. Well, aloha, everyone. Shihushi Erika Partee. I am the Natural Resources Director for the Tolowa Designation, located in Smith River, California. And I'm here with my colleagues today to talk to you about a paper entitled Revitalizing Stewardship and Use of Tribal Traditional Territories, Options for Improving California Policy and Law in State-Managed Lands and Waters. I'm going to go ahead and pass it over to Curtis Berkey and Erika Costa for introductions, and then we will jump into the topic.
Erika?
Sure. Well, hello, everybody. Thanks so much for joining us today. My name is Erika Costa. I am Pomo from the Sherwood Valley Band of Pomo Indians and Wailaki from the Round Valley Indian Tribes. I'm an associate attorney at Berkey Williams LLP and excited to talk with you all about this paper today. So thanks so much for joining and for having me.
Good morning, everyone. Curtis Berkey, partner at Berkey Williams, tribal attorney for 40 some years, and worked with Erika. And we had another Erika Costa on this paper. We had another author, Viva Simon, who's also an associate in our firm. And this paper has been downloaded. It's available. It's public. We're hoping actually to get it published in a law review, and that'll probably happen in the next couple of months or so. But what we wanted to do was we can touch on some of the issues in the paper, not all of them in the time we have, but we're eager to hear your questions. We'd like to make this conversation to the extent the technology allows for that. We have we've organized our presentation, starting with Erika Partee and then Erika Costa and myself. So we will run through that, and but please interrupt with questions and comments as we go along.
All right, well, let's jump into it. So I'm the Natural Resources Director for the Tolowa Designation. I pulled up a map of the Ancestral territory, and this is a federally recognized tribe with about 1,700 enrolled tribal citizens. We're in an interesting situation because it's a federally recognized tribe in California, but the majority of our ancestral territory is in Oregon. However, with that status and with our base of operations being located out in Smith River, California, most of our focus is on that immediate area.
Sorry, Erika, to disrupt you, but on my end, the audio is a little choppy. I don't know if everyone else is getting it.
Oh, sure.
There we go. You're clear right there.
Yeah, that's better.
Yeah, that's better. Yeah.
I'll move closer to the computer. Sure. And so in the Natural Resources Department, we have the mission of preserving and protecting the natural and cultural resources of both the Tolowa Designation and the Tolowa Aboriginal Territory. Our department honors this mission through a number of programs and services, but all are working towards the goal of promoting culturally appropriate stewardship of tribal lands, air, water, and resources. Our department includes 4 main divisions. We have the Marine Division, Fisheries Division, the Habitat and Wildlife Division, and the Tipo NAGPRA Division. Just really reiterating that, cultural and natural resources are all cultural resources. And so we're glad to have those programs, supporting our work on the day-to-day basis. We as staff are responsible for issues and projects pertaining to water, air, solid waste, watershed health, water quality, ocean protection, and terrestrial and aquatic wildlife and plants. And together, those constitute some of our cultural and natural resources. So today, we are on to share kind of our experience in relation to some of the tools that Curtis and Berkey Williams, all of the authors, have included in this paper on how to really increase public access through the existing mechanisms that the state has. And to kick that off, we just want to do a quick review of some of the policies that have come out over the last several years that have really facilitated us moving forward on a lot of the topics addressed in this paper. So, in California, and we are speaking, I do want to clarify that we're speaking from the perspective of California and referring mainly to those California policies and laws. But on June 18, 2019, Governor Newsom passed California Executive Order N-1519. This was historic in that it recognized and apologized on behalf of the state for historical violence, exploitation, dispossession, and the attempted destruction of tribal communities. In addition, this EO provided for the creation of the Truth and Healing Council and really reiterated the importance of Executive Order B-1011, passed previously, that it's the policy of the administration that every state agency and department subject to executive control is to encourage communication and consultation with California Native American tribes. Now, more recently, in October of 2020, California Executive Order N-8220 really put on paper acknowledgement of the fact that since time immemorial, California Native Americans have stewarded, managed, and lived interdependently with the lands that now make up the state of California, and calls specifically on, as a number of things in this executive order, but calls specifically for the development of the Natural and Working Lands Climate Smart Strategy that serves as a framework to advance the state's carbon neutrality goal and builds climate resilience. So in respect to, some of these broader state goals for management and stewardship, specifically acknowledging that the tribes hold information that will be, valuable to those efforts. Now, on September 25th, 2020, the Executive Office released the California Statement of Administration Policy on Native American Ancestral Lands. I'm sure that many people on this panel or watching the panel are familiar with this. The purpose of this was essentially to partner with California tribes to facilitate tribal access, use, and co-management of state-owned or controlled natural lands, and to work cooperatively with California tribes that are interested in acquiring natural lands in excess of state needs. And really in this, it provides specific actionable calls for entering into memoranda of understanding to allow for access to or co-management of natural lands under the ownership or control of the state with California tribes in order to assess their lands and
I'm sorry, Erika. One more. It's garbled again. Maybe if you want to shut off your video in the meantime. I don't know if that's a bandwidth issue.
Oh, sure. Let me get on here.
Oh, wait, you're doing a presentation though. Sorry. Okay.
I'll go ahead and turn my camera off and then share it again.
Sorry about that.
Oh, no worries. Thank you. I appreciate that. For letting us know. So these state policies really have set the stage for it, particularly within, our experience at the Tolowa Dee-ni Nation, some accelerated development of actions, I think, that would be working towards co-management with the state of our traditional cultural properties. Just a little history on Tolowa Dee-ni engagement. We really view co-management as a call to shared stewardship of resources we truly believe, at the Tolowa Designation that we're stewards of the natural world. We're not managers of it. So, the history around the creation of this marine protected areas within the state of California really was what led to the development of our department's capacity. And, through that process, it really was the first time that the state had engaged with the tribes based on tribal pressure to, incorporate tribal uses into some of their management activities. And since 2012, since the North Coast Marine Protected Areas have been established, our Marine Division has grown significantly and been a major contributor to that effort. In the areas that we have, shared resources of concern, shared marine species of concern, we've been able to protect the use of those species by our tribal citizens, but then also work with the state to provide some mechanisms to allow for tribal monitoring of those resources. And this works well with our tribe's harvest title, which is doing the same thing, but, within our own tribal title. And so we really see the meeting of kind of these two objectives for monitoring and protection as a way to set the stage for kind of some of that conversation around shared stewardship. Since then, our department, the Marine Division, and really advocacy of the tribe on behalf of tribal and cultural resources have led to first the development of the stewards program, but then also participation in foundational membership in the tribal marine stewards. We really want to highlight that activity as something that is an on-the-ground show of resource allocation to the tribes in order to support co-management objectives. It's something that we see as both parties' responsibility, but often only supported by, resources either provided by the tribe or by the state for their own staff. Since the passage of these executive orders as well, we've been engaging more, particularly with the California Department of Fish and Wildlife, on memoranda of agreements that specifically reference projects where we are collaborating or receiving some sort of state support. And so, we've recently entered an MOA with Cdfw providing for equipment loan and site use for a sonar monitoring project on the Smith River, where, for the first time in many years, the tribe has initiated adult salmon counts again. This has been a huge gap for the Smith River in general, but really a huge priority for our department. And so, we're glad to be undertaking that work now and having the support of Cdfw. It does kind of speak to our different perspectives on what co-management or shared stewardship would be, though. And so we also entered MOAs with the state on other resource issues. We have an established one that we're in the process of updating for elk tagging and monitoring.
Yeah, I was doing.
And then I will point to some other examples of, multi-species or single species MOAs that the department has also entered in with additional tribes in the northern and central regions of the state. What we've really found these executive orders have done for these shared stewardship agreements are made them go a lot faster. These were activities, a lot of them that we had been trying to engage in for several years prior to the passing of these executive orders. And it seems like it's given, our state agencies clearance to move them forward more quickly, be more flexible, and really assign individual staff to help kind of shepherd them to completion. I would say that, one of the main reasons or methods that we've been able to facilitate creation of our current MOAs with the state, but also discuss future MOAs, is through Cdfw's assignation of tribal liaisons to the individual regions. This was an area where we used to have, one statewide tribal liaison. And then recently, we now have two that we're communicating with within the region, one on fish issues and one on wildlife issues. Really having a single point person at these agencies to deal with jumping through kind of the administrative hoops on the agency side has been very helpful. In terms of, the success and the limitations of these co-management agreements, I would say, some of the successes would be that they've allowed for that shared responsibility and stewardship. It's allowed for kind of that recognition that the tribes have raised the capacity to be able to take on some of that stewardship, but also that, they are the original stewards of these properties and areas and these resources. Really, I think that where these successes start to become limits to co-management would be, every MOA we've seen, regardless of whether it's with our tribe or with another tribe in the state, they all work within the confines of the current state take allocations and existing state laws. And we did not develop those cooperatively. They also do not provide for any allocation of resources for doing the shared stewardship work. It's still been up to our staff and our tribe to fund any work that's come out of these MOAs. So even though we're collaborating on, the content of the project, we've yet to see that collaboration extend to shared resources between the state agencies and the tribes. The exception to this will be the Tribal Marine Stewards Network, which, is a group and effort that has started OPC in the last year and includes a consortia of tribes that are actually given a pot of base funding to do monitoring on the MPA network within those areas of shared concern.
Real quick, sorry again. How much longer is your section of this?
I am just, I'm just about wrapped up.
Okay, sorry, it just kept cutting out.
No worries, and I apologize for the audio that kind of tripped me up, but I'm going to pass it over to Erika Costa to talk about some current law and laws that don't exist. And so, Erika, I think when you're ready for me to change slides, just...
Yeah, I'll just let you know. Sounds good. Thanks, Erika. We like to make it confusing for the attendees. Really make sure you're paying attention by having two Erikas on the panel. So it's our little way of keeping you all awake as we move closer to the lunch hour. So thanks again. And as Erika said, I'm going to provide sorry, I want to start my timer so I make sure I don't take up too much time. I'm going to provide a brief overview of existing state law and policy regarding the current ability of California Indian tribes to access state lands off reservation for culturally oriented management purposes, including ceremonies and also traditional fishing, hunting, and gathering. So that's what I'm going to talk about. But before I do, I kind of just want to highlight that, the policy and legal categories of use, access, management that I'm going to talk about within the state law context don't fully embrace or describe, or I think necessarily acknowledge the profound scope and nature of tribal relationships with these places and practices. So I think that's an important piece moving forward, thinking about these how to translate that into policy and legal prescriptions moving forward, how that can be folded in. So I think just real quick before I jump into an overview of existing state law, I want to give folks just a quick reminder from the sort of Indian law perspective that, generally speaking, outside of Indian reservations or outside of trust land that's held in trust by the United States on behalf of tribes, state laws generally apply to Indian tribes in the absence of federal law, expressly to the contrary, such as treaties securing off-reservation hunting, fishing, or gathering rights. So as a result, tribal legal authorization to access, manage, fish, hunt, and gather on state lands generally must be found in specific state laws, regulations, and policies. So I'm going to talk a little bit about what's currently in state laws, regulation, and policies, and sort of the gaps there too. Erika, do you want to go ahead and go to the next slide and we can talk about access? So at this time, and at the time of writing this paper, I'm not aware, and the research didn't disclose any state laws or regulations that specifically or explicitly confirm the right and responsibilities of California tribes generally to access state lands and waters for management and stewardship purposes. But just to briefly touch again on something that Erika mentioned earlier regarding California Governor Newsom's 2020 policy regarding Native American ancestral lands. This is, I think, an excellent example of positive steps in the direction of recognizing tribal rights to manage and steward lands and access for that. Part of that policy encourages every state agency, departments, boards, commissions, subject to the state's executive control to quote, seek opportunities to support California tribes' co-management of and access to natural lands that are within California tribes' traditional land and under the ownership or control of the state of California, and work cooperatively, with California tribes that are interested in acquiring natural lands in excess of state needs. So, this is exactly what we're talking about. That it's on the governor's mind, it's on the state's mind of the need to move forward in addressing this. But there's a step further that's needed here, and that's that this policy is a positive step forward, but it doesn't mandate compliance by any of the state agency, and sort of leaves the implementation part up to agencies' discretion. And just one other thing I want to highlight here is other attempts to codify tribal specific rights to access and manage state lands in state law. Assembly Bill AB 3030 was introduced in February of 2020, and it proposed making changes to the California Public Resources Code. It would have authorized the state to consult with tribes when state conservation efforts impact tribal traditional homelands, and had the specific intent of helping restore tribal access to those lands and maintain or restore tribal land management, stewardship, and ownership. So although AB 3030 was not successful, I think it and the Native American Ancestral Lands policy certainly illustrated a desire on the part of the state to move in the right direction. Erika, you want to advance the next slide and we can talk about fishing? So current California state laws recognize tribal rights to continue practicing traditional fishing in tribal Aboriginal territories. State laws that recognize that are all limited to specific tribes, specific species taken, and also to designated places and times of the year. So California doesn't provide a general tribal right to fish outside reservation boundaries. They're pretty, like I said, tribal time and fish specific. So, for example, the state, through amendments to the California Code of Regulations and the California Fish and Game Code, recognized the right of specific tribes to fish outside reservation boundaries and conduct traditional fishing practices, kind of contrary to other state law. And those 6 tribes are Karuk, Pit River, Maidu, Yurok, Round Valley, and Hoopa. So, as I said, they're very, very specific. The California Code of Regulations also confirms the California Department of Fish and Wildlife's authority to enter into state tribal agreements governing fishing outside reservation boundaries specifically with two tribes, the Round Valley Indian tribes, or excuse me, three tribes, the Round Valley Indian tribes, the Hoopa Valley tribes, and the Yurok tribe as well. And that's subject to approval by the Fish and Game Commission. And then finally, another area that's really targeted to specific tribes, locations, times, and things like that is the California Code of Regulations regarding marine protected areas. Erika talked about this earlier, and marine managed areas. The California Code includes specific exemptions applicable again to specific tribes, locations, and times when conducting traditional fishing and harvesting and gathering. So that's sort of a really high level overview of current state policy specific to tribal off-reservation fishing rights. Let's go ahead, Erika, and we can move on to hunting. So the state's hunting regulations allow tribes and tribal members to transport game birds and mammals off the reservation, again, under certain circumstances. A lot of these, you'll hear a common theme throughout this, is it's very kind of narrow and falls under certain conditions and requirements. But otherwise, the hunting regulations don't directly recognize a tribal specific right to hunt and fish. You're hearing that as a common theme as well, not a general recognition within these laws of hunting, fishing, or gathering rights on state lands. But again, I think this is a place where the state is taking positive steps forward to work directly with tribes to recognize, acknowledge, and accommodate tribal cultural hunting practices on state lands. For example, in 2020, the California Department of Fish and Wildlife entered into a memorandum of agreement with the Bishop Paiute tribe, which authorized the tribe to take deer within hunting zones outside the tribe's reservation within the general hunting season, but it also allowed the tribe to take deer in two hunting zones before the general season, so outside of the hunting season. So it's an example of a government to government agreement acknowledging tribal traditional and cultural hunting rights on Aboriginal territories outside the tribe's reservation. Let's see. Let's go ahead and move to gathering. The next slide, Erika. Thank you. So in terms of tribal gathering practices on state lands and within state waters, particularly in the context of state managed coastal lands and marine waters, tribal gathering practices are severely inhibited by a combination of restrictive state laws and also overuse and population decline and collapse caused by climate change. So this is a particular area gathering within, particularly those coastal areas, that's really, really difficult and restrictive for Indian tribes in California. Just a couple examples are abalone, seaweed, and smelt surfish are three species of high cultural importance to many tribes. And for probably decades now, tribes have had to contend with take limits for these species imposed by the state, due in large part to over harvesting by commercial and recreational harvesting and climate change too. For example, the California Department of Fish and Wildlife closed the abalone harvest season in 2018 due to drastically declining numbers, and subsequently, more recently, extended that closure to 2026 to try to give the species an opportunity to bounce back. But part of that process is kelp is a major food. This is talking about obviously how the whole ecosystem works together. Kelp is a major food source for abalone. And since 2016, kelp forests along California's coast have suffered severe declines as well. So the food source for the abalone is impacted as well. There are also state laws and regulations prohibiting and restricting tribal gathering practices on state lands and state parks. And a lot of this is in really stark contrast to federal law. Just a couple examples here of, the National Park Services regulations allow tribes to enter into agreements or encourage tribes to enter in agreements with the superintendent that authorizes tribes to practice traditional gathering and removal of plants for traditional purposes on national park lands. And also the Secretary of Interior issued an order which directed the bureaus within the Department of Interior, that's National Park Service, BLM, Bureau of Land Management, Fish and Wildlife Service, to try and identify opportunities for cooperative management arrangements and collaborative relationships with federally recognized tribes. So that's like I said, a really high level overview of access to manage and steward, fishing, hunting, and gathering. Hopefully I didn't go too fast, but before I end and pass it over to Curtis, I just want to give a really quick sort of discussion on, or touch on, 4 potential legal bases that might support assertion of tribal off-reservation rights. One of those is, oh, sorry, Erika, can you go to the next slide? Thank you. One of those is treaties securing off-reservation rights. I think a lot of folks know, but just as a reminder, due to the failure on the part of the United States Senate, supported by the state of California at the time, at the state of California's urging, dozens of treaties that were negotiated with California Indian tribes between 1851 and 1852 were never ratified. So there aren't many treaties in California with tribes, but there are 3 from our research with the Tolowa Dee-ni Nation, the Kashaya Band of Pomo Indians, and the Hoopa Valley tribes. So they might be exceptions to this principle of no treaties in the state of California. So that's one species. Aboriginal title is another one. Under the doctrine of Aboriginal title, there might be an argument that tribes still hold a form of title to lands that were transferred to the state. And then the last 2 are tribal rights by implication from statutes or executive orders. Off-reservation use and access rights might be implied from the creation of Indian reservations by statute or an executive order. Some folks might be familiar with the Winters Doctrine and the implied water rights that are associated with the creation of an Indian reservation. And then finally is based on tribes' inherent sovereignty and inherent sovereign authority over the conduct of their tribal members on Aboriginal or traditional territory outside lands, outside the reservation. And under this theory, tribal regulation would preempt state regulation as a matter of federal law. So again, really high level overview of some of these bases. And it's important to remember too that each of these theories raises complex legal, factual issues and questions. And these theories haven't been tested in court. So with that, my timer just went off. I'm going to pass it over to my colleague, Curtis Berkey, to talk about some options for policy and regulatory changes to address these gaps.
Right. Thanks, Erika, and thanks to both Erikas for that those lucid presentations. I wanted to, before I get into what I prepared to say, I wanted to answer and comment on some of the questions that we have if this is a good time to do that. I want to make sure we don't run out of time to address those. There was a point that an MOU is not necessarily co-management, and we shouldn't conflate those two, or they're not equal. They're not the same thing. I think that's a good point, because if we loosely use the term co-management to describe a relationship that in fact is not a genuine sharing of authority, over the land and the resources, it's going to lose its meaning if it's too loosely used. Not that Erika was doing that, but I think the point is that co-management is a term of art, and it has legal meaning, and we should only apply it to those situations where in fact that is what the relationship reflects. So that's a good point. Thank you, Shauna, for that. I think the link to the government policy, I think Geneva provided that. I think that's in the chat. And then there was a good question about how did those provisions of the Code of Regulations in California that apply to specific tribes, how did those come about? And that's a good question. I'm not sure we know the answer to that. I have some guesses. I think that the HOOPA and UROC provisions really came about because of the decades-long litigation that was conducted on the Klamath River and the Trinity River by those tribes, resisting state law enforcement authority over the fishery and establishing a right derived from their executive order reservations, as Erika mentioned, that the state eventually came around to recognize. So I think the code provisions are a response to that. Round Valley, that was a pilot project actually, and we represent them on the Eel River matters. Our firm does, and I'm embarrassed to say I don't actually know what came of that pilot project. How it was implemented or whether it was implemented or not. But all of these would have been the subject of hearings at the Fish and Game Commission, with proposed language and public hearings, as well as, we would hope, consultation with the tribes directly. The Maidu case on the Feather River, I think that's on the Feather River. I don't know how that came up. I think that was part of the department of Fish and Game at the time reached out to the Maidu and was adopting some kind of a management plan. And I think it was through those discussions that they were willing to acknowledge that the Maidu would have a right to take fish out of season according to their traditional methods of take, which was kind of a significant advance at the time. So that's what we know about that. And then there was a comment at the end of Erika's Costa's presentation, noting that tribes can only gather on tribal land legally. And that is a very good summary of kind of where we are. As you can tell from Erika's presentation, from the tribal perspective, the ability to access resources, to fish, hunt, and gather, or to share in co-management responsibilities on state lands and waters is grossly inadequate. I mean, it doesn't really, the legal basis for this is not very strong. And the 3 or 4 legal theories that Erika sketched out there have not been tested, as she said, in court. And, as lawyers, we're not providing legal advice today, but we would not recommend doing that, actually. I mean, I think the Aboriginal claim might be the strongest, but it's fraught with risk and cost, and litigation does not seem to be a clear path to establishing and to obtaining that recognition and respect for those rights. So what we did in the paper, we came up with a menu of I think it's about 7 options based on existing authority that the state agencies have, the governor's office have, which would not require. Well, actually, one of them is a kind of a catch-all to change the current regulations or the current law through legislation to bring this legal protection about, and that's obviously a path that's open and an avenue that's available. Erika talked about co-management. There are some opportunities there. I won't go into these in great detail in light of the amount of time we have, but conservation easements is another way to do this. The state has authority to place easements on state land. It hasn't been done very often. The tribes are authorized under California law to hold conservation easements. Easements can provide access and use rights as long as they're spelled out and consistent with the conservation values that the easement's designed to protect. I think that's kind of an unused tool. Hasn't been used very much, but it's available. There's a special provision having to do with some marine areas that authorize the creation of cultural reserves I'm not sure that the legislature or the Fish and Game Commission had Indian tribes in mind when they drafted that, but it is legal authority. It is available, and there are some limits on what you could do in a cultural reserve, but that's available. Many of you are probably familiar with joint powers agreements, agreements between sovereigns within the state, counties, cities, state agencies, where sovereign governmental authority is shared under terms that are spelled out in an agreement. The department recently entered into an agreement with the tribe to authorize the take of deer, a number of deer out of season in the Aboriginal territory of this tribe under a scientific collection permit, which is quite a creative use of that provision. I'm not aware that that's ever been used before. It's something we actually considered in the Marine Life Protection Act initiative. The tribes looked at that. It didn't seem like it was broad enough or gave us enough flexibility in that context. But there is an MOA that relies on that legal authority to do that. And then the regulatory and legislative changes I mentioned. Now the one part, and by the way, I should say that none of these are not options that any tribe has endorsed. These are ideas that we as lawyers and people who've worked with tribes for decades have studied the state law, as Erika explained, have come up with. Whatever is done with this is up to the tribes themselves and the department and the state agencies. We're not endorsing any of these in particular or urging any particular one to be adopted at this point. We don't have a client that has decided to pursue a particular option. It's up to the tribes to decide, what the next steps might be. But the one item on this list of 7 that I want to talk about in the time that's remaining is land return. And that's a big one, obviously. That's momentous. As Erika mentioned, the unratified treaties in California, the 18 treaties, resulted in the loss of about 66, almost 67 million acres of land. And we know that today, almost all of the state land and waters was at one time the Aboriginal territory of Indian tribes. I think that's a given. I think everybody agrees with that. So an obvious way to solve the problem of lack of access and use rights on state lands is to turn that land over to tribes. Now that's a bold and momentous proposal. Now the Lone Pine Paiute Shoshones over on the eastern Sierras just recently entered into an agreement by which I believe the number is 40 acres was transferred to them. It was involved Caltrans and some mitigation, I believe, for some environmental damage that Caltrans had caused, and this land was conveyed. This was state land that was conveyed to the tribe. So it has been done. It in small numbers of acres, but that's very significant. Extraordinary, kind of remarkable result there. So land return is I see I have about 6 minutes left to talk about the most difficult issue here. Voluntary conveyance. Let me just say this: voluntary conveyance is with the state is preferable to litigation. We mentioned that before. The legal challenges for a claim per se against the state are enormous, involving the Indian Claims Commission, statute of limitations, the long passage of time, and those kinds of things. But to the state's credit, there is a recognition that the return of land needs to be in the conversation. The governor's proclamation, an executive order about tribal relations recently, specifically endorsed the return of so-called excess state land to Indian tribes. Now that term isn't defined in the order, but I believe that it probably references the surplus land provisions of state law. What that means in a particular context, remains to be determined. But that's a very significant policy statement that when there's land, the state no longer needs to, the state agency no longer needs to carry out its mission. There should be discussions about returning that land to the tribe. So that's a very important development. And many of you probably know, the California Public Utilities Commission this year, or maybe it was last year, adopted a policy that gives Indian tribes a right of first refusal if they regulated a utility. More likely than not, it's PG&E, but there is Southern Edison in Southern California, has lands that they've put on the market to sell. In other words, the tribes have the right to buy that land first, to negotiate a sale of a transfer of that land before the utility can talk to anybody else about a transfer. I don't know of any case revoked, but there's a very careful process they went through to adopt that, and that's another tool that's available. You also may know that CAL FIRE is receiving about 13,000 acres of land from PG&E as part of the PG&E bankruptcy, not the most recent one, but the one before the one that just happened last year. And CAL FIRE adopted what they call a Pacific Gas and Electric Lands Action Plan for Native American Tribal Relations, which may well include the possibility of some of that land going back to Indian tribes. And PG&E is actually doing that when their bankruptcy from how many years ago now with the Stewardship Council it's returned probably thousands of acres actually to Indian tribes through that process. That's a regulated utility. PG&E technically not a state agency, but nonetheless, these things are starting to happen. I would just say that this ought to be part of the conversation. I think. I mean, it may be threatening to state agencies. It may be possible to start small. One thing for tribes to carefully think about, and we wanted to have Hawk Rosales on the panel, but he had a family emergency, was unable to attend. But he wanted to emphasize that because he works with the InterTribal Sinkyone Wilderness Council, and one of the first questions that they always face is, do you have the capacity to take on the management and ownership of either private lands or state lands? And that's something that needs to be carefully thought through, because it is expensive and it is time consuming, and it can be a burden. So that's something to think about as well. So we have a minute and 43 seconds left. I'm not sure. Were there other questions in the chat?
Hey, Curtis. Yeah, there's one by James. Do you see
Okay.
it? You want me to read it?
Is that the one partner with Refuge
Yes.
and Homeland of Washoe to include? Yeah, for future harvest. Let's see. James, I'm not aware that there is such an agreement. That may be something will have to be created. You're asking whether there may be a template of some kind, to allow for future harvest. And I assume this is on state. I mean, I know you can't respond in a live way here, but I'm assuming you mean this is on state land. And so the question is it possible to develop an agreement to harvest culturally important plants as part of a restoration plan? I mean, I think that's legally permitted. I don't see any legal obstacle to doing that. I'm not aware that it's been done, but that's not a reason that nonetheless you should pursue it. I mean, I think that's a great idea. I mean, this is the kind of thing that will help us understand kind of what the limits of state law might be, and whether changes in the regulations or changes in the statute, need to occur. I don't know if that answers your question. What the next question is, what kind of agreements to pursue for access to state refuge? By state refuge, let's see. Erika, you want to take that one?
Which Erika?
I know.
All right.
I guess I'm not sure too what access to state refuge is. I think that might be not necessarily a term of art, but something specific that I don't know particularly, what that is. But it seems to me, Curtis, what you were saying is, there might be an opportunity there for negotiating some sort of MOU that is maybe a companion to a MOU, a memorandum of understanding, or a memorandum of agreement with the agency that's sort of a companion or maybe an exhibit, attachment to a restoration plan. That might be the opportunity to do that. So I think that's probably what sort of agreement might be pursued there.
Yeah, and I'd like to add to that, this discussion of MOAs and co-management, I would say if you're having these resource concerns, or access issues with any of your state agencies, pursue that option of an MOA, and you don't know, what will happen. I mean, what we've found is since these executive orders came out, our collaboration with the state is moving more smoothly. And I do appreciate Shauna pointing that out, that MOUs, they're not co-management. And so where that's touted in the EO as the tool to do that, really it's providing for really just green lighting, working with the individual tribes to deal with either their specific access issues or deal with specific projects. Every MOA that we've entered with the state has been on an issue that we had been either pushing them to monitor or seeking to monitor ourselves and not getting the support we needed. And so, these aren't groundbreaking agreements, but if there are places that you've been hitting dead ends with the agencies, they seem to have that flexibility and dedicated staff to really take a look at those again and see if it's something that they could individually address with a tribe.
And there was a question about capacity. What is meant by capacity? That's a good question. Let me back up and say that it may well be that if an Indian tribe is able to negotiate a transfer of state lands, that the state agency would insist on certain restrictions on use either in the deed or maybe as part of a conservation easement, in order to make sure that the mission of the agency and the state laws under which it operates and the values that reflects, are continued on those lands. So then that's a subject of negotiation. To that extent, capacity would mean the ability to monitor how the land is used, to ensure that those restrictions are complied with. There'll be questions about trespassing, and I mean any kind of what by capacity I mean having the staff and the budget to basically manage the land, just like you're managing tribal lands now. And maybe it wouldn't be depending on the size of the area and its access. If it may not be a big problem. You might have the public coming in and using the land illegally, or maybe pursuant to the provision of an easement of some kind. That's going to have to be monitored and the rights enforced. So it's that kind. It's basically staffing and budget is what I had in mind by capacity. I don't know if that answers your question or not, but that's the idea. So, well, that's all I had, Erika. So, I guess we're past our time, but yeah.
Yeah.
Go ahead, David.
Thank you, Erika South, Erika North. Thank you, Curtis. Thank you for everyone at participated, left comments, shared information is great. I don't know if any of you are still available to jump to a lounge, but I know we have our schedule. If not, if you have time, we can suggest a lounge that you can jump into, or are the speakers available?
Erika, Costa and I have another call at noon in 6 minutes, so apologies for that.
Okay.
I can be available for a few minutes, but then we actually have our tribal council meets today, so we will be joining them in a moment.
Okay.
You know, and just to speak again real quickly to the comments, you know, Sean has commented in order to build capacity, tribes need dedicated funding from the state to help build tribal programs. I absolutely agree. And especially, you know, as we're building that capacity, you're beginning to speak of, you know, land back, land transfer. It's, you know, we want to make sure that in excess of state needs doesn't become kind of synonymous, you know, like within deficit of state resources to manage those lands. So, you know, up here we're seeing with a lot of our state lands, the state doesn't necessarily have the capacity to manage those adequately, you know, and to assume that land transfer would basically be in lieu of any of that, you know, shared stewardship responsibility is kind of a dangerous experiment. And I would say, you know, land return and land transfer, it wouldn't, while we're glad that this is finally being addressed, you know, on its face by the state, and it's part of this conversation, we have a long way to go before that, coupled with, you know, building both the state and the tribal resources to steward those lands, actually become the. And so trying to push the state, you know, on those individual issues through these MOAs and the tools that they're providing can probably help us get there. I would point to, you know, that Tribal Marine Stewards Network. They provided the basis for funding tribes, you know, without being specific in their requirements for what tribes are using the funding for. More opportunities for, you know, state funds to be transferred to tribes to build that staff capacity, both on the planning side, but then, you know, like you're saying, Curtis, on the actually land ownership side.
Mm-hmm.
It takes a lot of manpower to, you know, maintain roads, maintain infrastructure, especially when a lot of these state lands that we're seeing are already, you know, under enforced and being utilized for trespass and illegal activities. So we do want to make sure that, you know, through that whole conversation of land transfer and land back, that's not touted as the only mechanism. We still are going to need those base funds and that support and technical assistance to, you know, increase our staffs to be able to accommodate those needs. But it's a good start, you know, and it's good to see. I really like this paper because these are all the mechanisms that already exist. These are what tribes are using now, or, you know, could be using now without having to reinvent the wheel. But it doesn't mean that the, you know, overall system or the wheel doesn't need to be reinvented, and true co-management is going to require that.
Yeah. Apologies, but I think we're going to have to ring off.
Three.
So,
All right.
thank you, everyone. This was great. We appreciate your participating.
And just a reminder, everybody, this will be on the website at a later date with the chat and the video. So if you want to come back and reference it. And again, thank you for all the speakers and the attendees.
Thanks, everyone.
Thank you.
you.